Commission, if you'll please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Pursuant to the provisions of Section 2.68.030 of the Metropolitan Code of Laws, notice is hereby given that if you're not satisfied with the decision made by the Metropolitan Transportation Licensing Commission, you may appeal the decision by petitioning for a writ of certiorari with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of the entry of the Metropolitan Transportation Licensing Commission's decision. We advise that you seek your own independent legal advice to ensure that your appeal is filed in a timely manner and that all procedural requirements have been met. Mr. Fields circulated our meeting minutes from last month. Has the Commission had an opportunity to review?
We have.
Is there a motion regarding approval?
I move to approve.
Second.
All those in favor?
Aye.
Motion passes. We have a public hearing today. We've received an application for a new booting company from Admiral Enforcement 2 LLC. Mr. Fields?
The ordinance requires a public hearing before any approval of an operation of a booting company can be done. We've reviewed the application. Everything appears to be in order, and we just need a public hearing to, in order for you to consider the application.
Has anyone submitted a request to speak?
No.
And the company is present.
Is there anyone here from the public that would like to speak regarding Admiral Enforcement's application? At this point in time, we'll close the public hearing. I know we've got the applicant.
I'm sorry. Excuse me.
I was just closing the public hearing portion.
Excuse me, Mr. Chairman.
Mr. Lawson, are you Mr. Lawson?
Yes.
Would you like to add anything to your application?
I would not. I just didn't know if the commission had any questions they needed to ask me.
All right. Commissioners, are there any questions regarding the application?
What's your experience and what's your interest in opening a booting company in Nashville?
Well, currently we are operating in 13 other cities in the country, and our client Premium Parking has landed a couple small parking lots here, 2 flat lots, one a 50 space, the other 45, so we're relatively small, and they've hired us to do the parking enforcement on those, whether it's issuing a citation or placing a boot.
I noticed your address is in New Orleans. Do you have an office? Will this 1012 Main Street be your office here?
That will be our office, yes.
Is that a brick and mortar physical office?
Until we gain scale here, that will be our corporate office address.
What is it actually?
It's in New Orleans.
Okay, your office is in New Orleans.
Correct. Our corporate office is in
1012 Main Street that you've listed here as the location description of place for your premises.
Correct.
What is that physically?
Those are 2 parking lots that are we're contracted through Premium Parking, both on Main Street, 1012 and 975. So those are the 2 lots that we will be enforcing.
So, I'm sorry, were you still?
No, go ahead, please.
So if there was a complaint over booting, the complainant would have to contact an office in New Orleans?
Yeah, well, we hand out appeal cards. So once the person is booted, they have the right to appeal. We have our own online website. It gives you step-by-step instructions on how to appeal. So anytime someone is booted, we give them that card. They have the right to appeal if they feel the boot was unjustified. And then it's all digital online.
So what's the turnaround on the appeal?
3 to 6 business days usually. And then if it's determined that it was an error on our part, or we decided that they tried to do the right thing, then we'd either issue a refund or a partial refund. If they paid by credit card, we just refund the card, If they paid by cash, we would send them a check.
So the boots are removed digitally? If they pay the fine, it'll release?
Correct, yeah. The boots are released once the fine's paid.
Who oversees your employees here?
It would be our senior enforcement agent in New Orleans. We're only going to have one part-time person right here. We're at a small scale right now, so we would only have one part-time person.
Thank you.
And the part-time person is an administrator or?
No, that's an
somebody-
actual booter. So
Who's-
once we have someone going through the process right now, we're waiting on drug test results, and then they have to also be licensed through the city of Nashville. So once we bring that person on board, they would have to go through the application process as a booter.
Mr. Fields, at this time, how many booting companies do we have? We have three.
I'm sorry, 4. We added one last year.
Are they typically attached to a parking company? Mr. Lawson says his company's attached to Premium, that's what's bringing you into Nashville, right?
Correct.
Typically, they make, typically booting company A works primarily with parking lot company A and B and C. It doesn't have to, but many times that's what it is. They just sign a contract with them, they handle all their lots.
Do any of the parking companies have their own booting personnel?
We don't allow that.
Okay.
So they can write their own, they can write their penalties and so forth, but in other words, they can have them towed, but they can't have them booted. They can't put the boots on, I should say.
But there does seem to be a pretty good, a close relationship between the parking lot companies and the booting companies.
Is 60 minutes, Mr. Fields, the typical time or maximum time allowed to remove the boot once the fee is paid?
That's the city ordinance.
Right.
Once we come into a new city, we do our research on how the city looks at booting, what are the major complaints. And here in Nashville, the 3 major complaints we found were booting companies booting someone as soon as they pull on the lot. They get out of their car, they go off. They're booting less than 2 minutes. The other complaint was the city of Nashville has a $50 max ordinance, but you can charge whatever you want for unpaid parking. Some companies are charging $140 for unpaid parking, which typically seems like a scam to us. So we charge by the 24-hour rate for unpaid parking, which is typically under $20. The third complaint was we saw a lot of customers saying that they were waited 2 hours, 4 hours, sometimes 5 hours for a boot release. We adhere by the city, which we be there in an hour, we take it off for free. We go a step above that. If we're 30 minutes late or longer, then we reduce it by half. So if our guys can't get out there in 30 minutes, it's $25. So if you pay within 60 minutes, then we reduce it another $20. So we have some incorporated discounts along with what we think goes above and beyond what the city requires.
How would you be there in an hour if you only have one part-time worker whose job it is to put the boots on the car?
So what would happen is if we boot somebody at 8 a.m. and that person doesn't leave till 5 p.m., that person would take the boot off during normal business hours. If the customer doesn't come back to the lot, then what we do is an end-of-shift removal. We take the boot off, issue a citation on the car. So by no means do we leave the boot on without having somebody there on duty. And when we gain scale, like in New Orleans and Austin, we're a 24-hour operation, then we have someone on the clock.
And at the present time, you just have 2 lots that are more or less adjacent.
Correct. They're close
They're
to each
within
other.
blocks of-
Right.
they're-
So the agent, if you're hiring a part-time agent, that person is going to stay on scene, basically. And he helps people, if you're paying by the app and you need to download the app, like he helps customers that way as well. So. All of our enforcement agents are required to wear body cameras, something else that we've recently passed with the city of Austin. Some of the ordinance we just did with Austin, we're looking to weed out the predatorial booting company. So we're working with the mayor's office and council members to get stricter booting laws, to have these guys wear body cameras. So if there's an issue with the city can simply request, hey, I'd like to see the body camera footage. You guys have that opportunity to view that. And typically when somebody's wearing a body camera, they're not going to do things they shouldn't be doing.
Where's the video stored that's recorded from the body camera?
It's dropped at the end of each shift. So when the agent is done with his shift, he puts it in the charger, and that automatically dumps to a hard drive. And if the city gets a complaint 4 days later, then it's our responsibility to research that and get that to the city.
That was my next question. How long do you store the data?
Usually 60 days. If somebody has a complaint, they're usually going to voice that complaint within the 60 days. And our vehicles, too, are professionally outfitted. We have dashboard cams on that. So when we're interacting with the customer, we have the agent park in front, so we're also capturing. If for some reason the body camera was malfunctioning, we have backup data for that. All our vehicles are GPS tracked as well.
Is this the actual vehicle that will be here?
Correct, yeah. All of them are Toyota Tacomas. So once our booting license is approved, typically we don't buy a $34,000 truck for just 2 lots. So we would gain scale before we started booting. So typically we would be writing citations until we gain scale. But if we gain scale quickly, we want to have our booting license in order.
When you say gain scale, are you talking about acquiring more parking
Correct,
lots
correct.
from Premier or other companies?
Other companies. Premium parking is our, and there are 2 different, premium and premier. So we have private companies too that hire us to do boot on demand, which means if there's a business and there's a nice restaurant adjacent to the location and they're taking up all their parking spaces where no one's coming to visit this location because all of the parking spaces, then they call us and we do a boot on demand. So we immobilize at the request of the customer.
Portable booting.
And we're working on self-removal too. We got it operational in New Orleans, which means if the customer comes back to their vehicle and it's booted, and they do a text to pay, they get a code to release the boot, or they can call us if they're physically unable to get on the ground and take the boot off, which saves the customer time. Typically, it's anywhere from 14 to 16 minutes is our response time, but self-removal could be quicker than that.
Will you be using traditional boots? Have you looked at the Barnacle and some of those others yet?
Yeah, the barnacles are very expensive. They're about $600, plus they're going through a lot of lawsuits. That is physically put on the windshield by suction cups. And if you have a small crack in your window and that suction cup is applied, it spiderwebs the glass. So Barnacle right now is going through a lot of lawsuits. It's typically not something we want to get involved with.
If a complaint was made by someone whose vehicle was booted, and I think that the commissioner was asking about this earlier, the complaint would come to Mr. Fields. He will have someone at your office in New Orleans he can contact right away?
Absolutely. We'll give you a personal contact 24/7 where you can reach out. And typically the cities we work with in New Orleans too, New Orleans has their commission to where they review booting complaints. The city typically has them work it out with us first, and if we can't get to a resolution, then they go to the city and complain as well. But they're free to go to you first as well. It's really up to what the customer decides.
What is your complaint ratio in the other cities?
Well, I mean, typically our biggest complaint is I'm from a small town in Oklahoma. I had no idea I was supposed to pay to park. There's some times where a person doesn't update their license plate. You can have 3 to 4 license plates on your account, and if you're in a car accident and you're taking a rental car in there and you forget to update your license plate, everything is license plate based on for us. So when we go onto the lot, we scan the license plate. One of the major complaints was, well, I was booted 2 minutes after I got there. Well, we have a built-in grace period, meaning when we see a plate that's not in the system, we set an automatic timer for 15 minutes. So this allows if the person's at the digital machine trying to pay, or they're walking back to their office and they're downloading the app trying to pay. So, as soon as you get out on the lot and walk away, we're not going to boot you. So this 15-minute grace period allows you time to get in the system. And if we identify that it's not in the system, that 15 minutes is up, or if they pay within that 15 minutes, the plate falls out and we don't take any enforcement action on it.
That would have solved the complaint we had in the last meeting.
And the good thing about premium parking too is everything is web-based. So if you're parked out here and it's storming and raining and you're about to expire in 10 minutes, the application sends you an alert saying, hey, you're about to expire in 15 minutes. Would you like to add more time? You don't have to physically walk out to feed the meters. It's really convenient for the customer.
Thank you, Mr. Lawson.
Sure.
Mr. Fields, you see any reason not to approve? I make a motion to approve the application by Admiral Enforcement, LLC.
I second the motion.
All those in favor?
Aye.
Motion passes. Next on the agenda is under wrecker and towing services. We've got two driver applications. Mr. Fields?
Vincent Jones? Mr. Jones? Vincent Jones, are you present? Mr. Jones' case was deferred from last month, and I think that it was some additional information. I think Mr. McNally wanted to do some additional information on the case, but Mr. Jones is not present, and he was present last month.
So was the prospective employer. Well, I worked so hard to get those warrants, too. I move to dismiss his application.
I second the motion.
All those in favor?
Aye.
Motion passes. Next is an application from Jackie Johnson, Jr.
Mr. Johnson? Come on, please. In making his application, he failed to disclose a 2019 child neglect and abuse charge. And that's what has him with you today.
Johnson, that was 2019?
Yes, sir.
You forgot to disclose that?
Well, I did the background check, and it come from a simple possession charge, and her age, being younger and actually being on the premises, is where the charge came into effect. Her being under 9 years old resulted into the child neglect / abuse charge for a simple possession of marijuana. And when I did the background check myself, I paid for it at the house. I actually put everything on there that came back, even the charge I had when I was 16, where I had got bound over to the adult justice system. And if I would have seen it on there, I would have absolutely put it, on my piece of paper. I put all my speeding tickets and everything else that showed up. It actually wasn't on my background check originally, so that's the only reason I didn't put it on there. But I had went all the way back to 1996. I think I was 16.
And those charges were
Completely dismissed.
dismissed?
Yes, sir. Once I went to court, it was plead guilty to the simple possession because I was the actual homeowner, and I felt it was right for me to take the charge since it was other people at my house. So, and that's exactly how the charge came. The judge had threw it completely out, dismissed, and I got 1129 probation, suspended sentence for the simple possession, community service, and $1,000 and $1,026 in fines.
You completed and paid all those?
The fines in the process of being paid now, but all the community service is done. Random drug screens through the probation officer, and it's all out of Robertson County, Greenbrier.
All right, so you had some friends over, there was some marijuana in the house.
Yes,
Your
sir.
child was in the house, and you got charged with the simple possession as well as endangerment of the child
Yes, sir.
because you had a child in a home where marijuana was being smoked.
Yeah, I was the homeowner. They
You were
was
the homeowner.
outside, and I was in the house with the child, so I actually took the charge. I mean, it was my house.
why did the police show up and why did they come in the house?
They actually come looking for my son's girlfriend that had run away from the house, her house. She got into a dispute with her mom, and he said he could smell it, which I told him it was outside. He came in, he didn't find anything in my actual house, but it was on my property.
When you say he, are you saying the
A police
Robertson
officer.
County Sheriff's Department?
Yes, sir, a police officer from Greenbrier.
Okay. So there was a report of a runaway, the police showed up, they smelled marijuana, they came in the house, found you and your daughter,
My goddaughter.
your goddaughter.
Yes, sir.
Okay.
Both of my children are grown, 21 and 19.
And he arrested you inside the house.
Outside on the front porch. He asked me to step outside, yes.
All right.
But he didn't actually get it out of my house. It was in a cellophane outside, sitting on a windowsill where everyone else was present.
Anybody else get charged?
No, sir, I took the charge. It was my residence. I actually worked for myself doing remodeling and flooring for 20 years, and I didn't want anybody to lose their job. I mean, you know, I worked for myself, and it would be termination for them. So at the time, I pled guilty to the charge.
What are you self-employed at?
I had Jack's Carpet for 20 years, subbed out of carpet stores in Franklin and Kevco Carpets in Lebanon, Home Depot and Lowe's. And I had 3 hernia surgeries, so I pretty much gave it up. And Michael said he'd give me a chance at the tow company, see what I could do. He offers 401k and insurance and stuff, which I didn't have at the time. You know, working for yourself is 1099 and a whole bunch of other stuff that goes into it. I wind up working for a little bit of nothing at the end of the week by the time I get hit with all the taxes and stuff, so, and it's hard work.
Mm-hmm.
And Michael was gonna come with me today, but his wife is real sick, but he did give me a letter saying that, you know, he would wish he could have made it, but Miss Wright was in the process of going to the hospital and stuff now.
Should I just read it out loud?
Sure.
It's written by Michael Martin
Yes, sir.
to the Davidson County Transportation Licensing Commission. I would like to thank you for the time today and apologize for not being able to make this meeting. I met Mr. Johnson through doing some landscape work on Martin's Wrecker Service property. He showed himself to be a hard worker, so when he inquired about a job, I told him we could find a position for him. If approved, he will be hired as a driver and will be subject to drug screening as all employees are. He will also receive training in flatbed and snatch truck operations and will be directed by our dispatch on calls during his shifts. Again, I thank you for your time considering Mr. Johnson for approval. Other than the disclosure of the dismissed charge, Mr. Fields, is there anything that would cause Mr. Johnson not to be qualified?
No, sir. Had he disclosed the charges, there are no disqualifiers that we could determine on the application.
Would anyone like to make a motion regarding Mr. Johnson's application?
Move to approve.
All those in favor?
Aye.
Motion passes. Thank you.
Thank you. Thank you.
Next, we've got, under other passenger vehicles for hire, a review of a company name change for Executive Transportation to Executive Transportation LLC. Mr. Fields?
Anytime there's a change to the face of an application, it has to be reviewed and approved by the commission. In this case, he's establishing a limited liability corporation, so he'd like to include that in the application. So it's in order.
Move to approve the Executive Transportation's name change.
I'll second.
All those in favor?
Aye.
Motion passes. Next, we have a new company application for EJK Transportation LLC.
Every new company has to appear in front of the commission for review, and we've reviewed the application. Everything's in order.
Move to approve.
Second.
All those in favor?
Aye.
Motion passes.
Relaxing rights asked that they be, it was on your original agenda, they've asked to be deferred to January. and does not require action.
All right, so we'll move that to January. Next, we've got complaints on the agenda. We've got a continuance of the complaints brought by American Melody Carriages and Melody Robinson against Sugar Creek Carriages. And I understand from Ms. Robinson that she has requested that we defer and further continue those complaints to next month.
Mr. Chairman, on behalf of the respondent, this is at least the third time that this has been here. We moved to dismiss. There is a context for this. She has been sued by Sugar Creek and by Mr. Smith. She sought a postponement of her deposition that was scheduled, in which various things could be discussed, including relentless Facebook posts, other social media, making outrageous claims, including you, Mr. Chairman, comments about you, comments about me, which I'm accustomed to in my line of work. Also accusing Mr. Smith of murder, and I'm not exaggerating, of burying a man in his field, a man that we have a recording of. He's well and truly alive. This is a grudge matter, and it's not my characterization. She has published one of these. I actually read to the commission a few months back, where she has threatened to do whatever she can to destroy Mr. Smith. She has tried to have, she's reported him to various agencies. We had last month, you'll recall, the matter involving a business license. I think we argued that that was beyond the jurisdiction of the commission, was not required with the application, and that was dismissed. I don't want to characterize your dismissal. It was just a vote to dismiss. And these three, we have moved to dismiss at least two of them based upon the fact that they were late filed outside the 30 days, 30-day period. So we do not, for the record, agree to any further continuance of these and move that all three be dismissed.
All right, Mr. Blackburn, we'll decide first whether or not we should defer the matters to next month's meeting before we address your motion to dismiss. Obviously, these matters have been pending for a while. We started to consider them at last month's meeting and ran out of time, and so we continued them to this month. Ms. Robinson has obviously known about these complaints and was present when we did continue her complaints to this month. We received the request to continue yesterday from Ms. Robinson. We certainly have the discretion to deny the request and to go ahead and hear the complaints on the merits without her being here, if we so choose, and also to consider Mr. Blackburn's motion. Given that we do have a limited amount of time as a commission when we meet once a month, given that Ms. Robinson knew about the fact that these complaints are going to be heard today, I don't think we should defer. I don't think we should continue. I think we should move forward with the complaints here and consider the motion that Mr. Blackburn would like to make and address him substantively.
Is there any hard proof photos, anything for the allegations of the batteries, the lights, the horse?
We have a photo we could offer of our that we took, but I've not been provided any that she has submitted.
Let's decide the issue of whether we continue first before we get into the merits.
Can I make an inquiry first, based upon the email I received from Melanie Robinson that I think went to everybody?
Yes.
And I do empathize and hear what the chairperson saying regarding hearing them today. But I want to know if this is accurate, and I don't know if the minutes would reflect it or what, but initially it says that Ms. Robinson states that initially Mr. Blackburn had deferred the complaints at the first setting, that twice thereafter there was no quorum and they were deferred, and then the fourth time they were deferred because they were at the end of the agenda and we ran out of time. Now, the last one I remember being accurate.
That's last month.
Yes. That is accurate, correct? Am I correct on that?
Well, there was no quorum for the September meeting.
Yeah, but on the last time, we just ran out of time,
Right.
right? Okay. There was no quorum for one meeting that I recall.
Well, there were actually 2 meetings.
Two meetings, so that could be
One meeting,
accurate as
actually,
well.
we were here, we were present. The other one we canceled prior to the appearing.
And Mr. Blackburn, I'm going to ask you, because I don't recall, but did you request that they be deferred one time?
It was,
Simple.
it was requested on my behalf. I was hospitalized in
That's
South
right.
Carolina,
Okay.
so yes.
Okay. All right, so what she states in her paragraph would be accurate? It would appear it's accurate then, right?
It would appear.
Okay. And now Ms. Robinson's asking for a deferral of 1 month because she has a Christmas carriage booking. All right. I don't know where to begin with this because, candidly, I know everybody on this commission has their patience has been tried with these complaints between the carriage companies. So,
And I have more. I think I'm up to 18.
You're taking the words right out of my mouth. I don't know. Is there anything that can be done? I mean, I feel like I have been on this commission for over a year now, and every single month that I have been here, there has been some sort of complaint back and forth with these companies, and it just seems endless. And thankfully today we have a shorter agenda, but sometimes we have other business that is extremely important to the mission of this commission, and to just constantly be hearing these complaints, I don't know.
well, I'm also sympathetic to the fact that Sugar Creek is paying for legal representation to defend these complaints, and they're here today, and that's costing them money as well. So,
If Mr. Chair,
what I
if
wanted to do was just make sure I put everything out in front of the commission before we decide on the issue of whether to defer or not.
This is not germane to that, but if, with your permission, Mr. Chairman, I can respond to Madam Commissioner's statement.
That's all I just feel like I'd like to decide the issue of whether we're going to defer.
My thoughts are even though it is adding to your burden as well as ours, due to your health, you had a chance to defer. Due to the board's deferment, it was also deferred a couple of times. I would think just in the due process of it that she would be at least given one time to defer it herself.
I would probably agree right off the bat on that, though it might not be popular, except for the fact that the reason for the deferment is that she wanted to take a job versus being here. And Ms. Robinson is the one who brought the complaints and ought to have a responsibility of being here to pursue them, even if she has to defer taking a booking.
And the only reason I say that is we, in council's deferment and our deferment, we don't know how many jobs she didn't accept to attend those, because I do know the one that we deferred, she was here, and stayed to the end, and we,
Right out of time.
yeah,
And then the other two, we didn't have a quorum.
exactly. And for one of the ones that we didn't have a quorum, I knew she was here for that one as well, so. I only say that to not knowing her schedule, how many jobs did she, not take, for all those deferrals? I don't want to revisit this. I love seeing your face, but I don't want to revisit this any more than you do. But it looks like if we're going to revisit it in some form or fashion, regardless, because as the other commissioner says, it's an ongoing dance. You know, our dance card is full. So it looks like we're going to be doing this two-step for a minute anyway.
What were your reasonings for wanting to go forward?
The number one reason is efficiency and notice. Ms. Robinson knew that we were going to meet today to address her complaints, and we only meet one time a month. We're not able to consider and confer on these complaints except once every month under the Open Meetings Act, and if we defer these, it's going to just burden the commission later on down the line when we have other complaints that we need to address. So that's why I'm against continuing the three complaints. I mean, Ms. Robinson is the complainant. She chose to, and there's nothing wrong with her decision, but she chose to prioritize, you know, a job, which is fine. I respect that, but the consequences is we have to make a decision, and I think our decision is we don't continue the hearing. We can still consider Ms. Robinson's position and address the complaints head on. We can consider Mr. Blackburn's motion to dismiss, but I think that we should do that. I don't think we should delay.
So we could either defer, not defer, grant Mr. Blackburn's motion to dismiss, or go forward with the merits of the complaints as written out by Ms. Robinson in her TLC complaints.
And I've considered that as well, that a lot of these complaints can just be addressed, but without the burden of her proof being in our presence, it kind of be one-sided. They show us a picture of a carriage with a battery and a light on it. You know, some of the other issues with the treatment of the animals. I mean, without her being able to provide her proof, it would pretty much be one-sided.
Well, one of the complaints has to do with rain, and whether the subjective decision of whether or not whether that rain amounted to adverse weather. I mean, that complaint to me does not seem to have any merit.
No, I agree with you on that one. But on the issue of the carriage lights, if she had some timestamp photo or videotape, that would be pretty much proof.
I'm all with you on the rain. You know, how can you determine really how much rain is detrimental? But she has another complaint on the parking outside the carriage stands and blocking crosswalks and double parked in streets. Those are things that photographs or videos could very much prove, and without her being given the chance to produce that, it would be a pretty much one-sided argument. My thoughts.
it sounds like Mr. McNally and Mr. Carr would be in favor of continuing. I don't know. Carrie, what do you think?
Let me make sure I understand the options. You're saying that we could take up the complaint today and make a decision?
Yes.
I'd be in favor of that. So should I make a motion?
You can make a motion.
I make a motion that we take up the complaint today.
Actually, I guess the motion would be to deny the request for continuance.
Well, that's what I was going to do next. But, okay. Just trying to move along.
Ms. Powell, do you have a position?
I feel like if we are going to hear this, that we should, do our best to make sure that everybody involved is here. So, with that, I wouldn't be seconding the motion that's currently on the table.
All right, well, it sounds like we're leaning 3-1 to grant Ms. Robinson's request, but we don't have a motion. Teresa, would we be able to consider Mr. Blackburn's motion to dismiss, though, even if we are willing to postpone the substantive complaint? If Mr. Blackburn obviously has a motion to dismiss, which, I know what that means as an attorney. I mean, he's basically arguing the position for Sugar Creek that the complaint is invalid on its face, and even if everything is correct and assumed to be true in the complaint, it still fails.
So I understand the distinction that you're making. His motion is on a procedural basis and doesn't get into the actual merits of the complaints themselves. I think that you all do have discretion to make that distinction if you wish to. Obviously, you have the same issue that she may have there are facts that also address the procedural issues involved in his motion, and it's possible that she would have a counter argument to his characterization of those. I don't know. And so without her being present, she would lose her opportunity to make any such counter argument that she might or might not have.
Well, I've got a motion now.
All right.
I would make a motion that we entertain Mr. Blackburn's legal arguments on his motion to dismiss today.
Second.
All those in favor?
Aye.
Motion passes. All right, Mr. Blackburn, you can make your argument on the motion to dismiss.
Thank you, Mr. Chairman. The history of this is there were 4 citations. One of those had to do with the business license. That was dismissed at the last meeting. So we have 3. Of these 3, one of them seems to be timely on its face, but that is the one involving the allegation of operating a carriage in the rain. Our position with regard to that is that what she has alleged, even if proved, does not demonstrate a violation of any ordinance. There's no citation here by a police officer. We were not here based upon the confines, and I agree with you, Mr. Chair, as to what I'm here to present. We do have adverse evidence on that, but nonetheless, I agree with the statements that have been made that doesn't really state a claim. That leaves.
Are you saying the June 23rd and the September 9th are untimely?
Yes, and
Right.
the way that happened was that you will see. In fact, this was pointed out by one of the commissioners the last time we were here. If you look on the forms themselves, they say that if these are not signed, they will not be processed. It's sort of like filing a lawsuit by fax in a county that doesn't accept faxes. It doesn't toll any statute of limitations. And so what occurred, and then you have the rule, I think sensibly based upon your experience with all of these complaints and operators going back some period of time and alleging things in the past, that these have to be presented within 30 days of the alleged incident. These two remaining ones were filed or submitted to the TLC, not signed. It's my understanding from comments that Mr. Fields made the last time is that he or someone on the staff returned these to her and pointed out they were not signed. By the time signatures were made, she didn't change any dates, but this constituted a new filing, which was plainly outside the 30-day period. Our argument on the first one was a legal one, and that is...
Is the June one the first one you're referring to?
I didn't pull... I've got all these here. The one involving the...
Business license?
Business license has already been disposed of.
Right. Then I have a operating in the rain. I have August 28th, 30th of improper lighting, and a June 1st for repeatedly parking in improper areas.
Start with the June 1st one. June 1st.
It's actually dated June 23rd.
Sorry.
Yeah.
This is a modified.
That's not June, that's August. The one that I referred to having to do with the rain, that's the August 7th one.
Correct.
The lighting, the one involving lighting, is dated June the 9th.
I've got September 9th.
September 9th.
I beg your pardon, that's a 9, not a 6.
Okay.
That's correct. September the 9th. This was one of those, if I understand correctly, and I hope Mr. Fields will correct me if this is not accurate. This is one of the two that was filed without a signature and returned, and then she signed it and returned it again without changing the date. It was then subsequently furnished. There were copies that were sent to me prior to one of these dates because I wanted to make sure I had the correct ones, and that's when I noticed that the ones that I received had signatures as opposed to the ones that were served, which did not. They actually were sent to Sugar Creek. The one dated June 23 of 19, I have copies here that were sent to us that were not signed. This one is defective in any event, if you happen to have that one before you. Sugar Creek carriages have consistently and repeatedly parked outside carriage stands and blocked crosswalks, double parked in streets and more, up to and including 6/1 of 19. There was that one does not state any date, time, place, carriage operator. It states nothing except a conclusory allegation that at some undefined time, described as repeatedly, someone parked outside a carriage stand. I don't believe that one is legally sufficient.
Is this a complaint you're arguing was not signed originally, or was this one?
Yes, Mr. Chairman, we have a copy of it without a signature that was served on Sugar Creek.
So your objection to the June 23rd complaint is that, one, it's untimely because it was not signed and dated as required within the 30 days.
Correct.
And then number two, that it fails to give sufficient notice in the facts of the complaint.
That's correct. There's no way to defend it because of the vagueness of it. That happened to be the same day that the business license complaint was filed, 6/23. Now, we didn't get to the facts of that because we argued that it should be dismissed because that's not the role of this commission. Mr. Smith had a business license in another county. The question was whether his operations required an additional business license in Davidson County. That's not for this commission to determine. Plus, at the time the application is made, business licenses are not required. One or the other, and I'm not trying to deal with this. One or the
But
other.
that's already been dismissed.
That's been dismissed.
So you won that one.
So I need
On the
to
September-
quit talking.
On the
you see.
September 9th one, on the September 9th one, you're raising the complaint that it was not signed within the 30 days and therefore it's untimely. And the September 9th one is the improper lighting.
That's correct, and that one is one of those that I believe was sent without a signature and was later resubmitted with a signature.
Mr. Fields, can you verify that?
It actually was brought to our attention by Mr. Blackburn's law firm. One of his associates sent a letter to the commission, or email stating basically what Mr. Blackburn has said, is they were not signed. We returned them to Miss Robinson for signature. She did sign them. In the case of the 8-7, it was actually annotated, I think, additionally.
What about the 9/9?
Were they all?
Do you have a copy, Mr. Blackburn, of the 9/9 that was served on your client that does not show a signature?
On the copy of several of mine, I can see where there was something whited out in the company name. Did she actually sign them in the wrong place? Is that what the problem was?
That was done. I noticed that.
Are we dealing with this for all three where they were not timely signed, or because I thought you said one of them was timely, you just are contesting it on other grounds?
Yes, there was one for which we didn't have that argument.
I think that was the August 7th one, wasn't it?
No, this is the lights.
It was the lights, the
So
9/9/19.
the September 9th one was timely.
Right.
Okay.
That's the one having to do with the lights.
I thought I just heard that the September 9th one was not dated and signed. Is that,
You did, yeah.
okay. So September 9th wasn't dated and signed, and then
But
That was the one that was signed.
Yeah.
was
They
dated.
changed their position,
Oh,
because I wrote that down myself.
okay.
Sorry, I have so
All right.
many.
Trying to keep up. Okay. So September 9th was dated and signed.
And the others are the ones that were returned and signed and refiled.
Both of which have the
Kind of whited out
like maybe it was signed in the wrong place. And then
I believe they actually whited out the company name above, is where the white.
Oh, I see, yeah.
And I apologize, I'm not certain I can produce original, as we advised you the last time. We did have a fire, and unfortunately, the fire actually happened right above the commission meeting materials. Since we deferred it from the meeting, it was still in the bad spot. So I apologize. We can certainly sift through the materials again.
Well, if you have copies that were sent to you that were unsigned, that would suffice.
This is the original one that was sent to us, without all the stuff scribbled on, and that was still edited.
Sounds like what we can do is deny that.
When was that signed?
I believe that's the only one that was.
I have two.
The one that was not signed.
Here's one, here's one that's not signed on my phone.
What's the date?
6/23.
Yeah, I know, we got that one.
There's two of them. Yeah,
Give you
I
all
gave
the
them
ones
two.
that we had based on looking at the wording of the actual 30-day rule. So we went and pulled the minutes of what's called the 30-day rule from the meeting at which you all adopted that rule. And here is what the motion says in the minutes, which would be the official record of it. Complaints by the public or regulated individuals or companies regarding taxi cabs, records, or other functions of the Transportation Licensing Commission must be filed in writing by the complainant. Anyone wishing to file a complaint may do so by letter, fax, or email. Upon request, a complaint form will be mailed. Complaints must be returned to the Commission office at least 14 days prior to a Commission meeting in order to be considered for the agenda. The Commission reserves the right to hear a complaint which does not meet the 14-day time period. Director Fields asked that all complaints be filed within 30 days from the incident. No one requested to speak, and the hearing was closed. After some discussion, Commissioner McNally, with a second from Commissioner Warren, moved to limit complaint filing to within 30 days of the incident. The TLC would reserve the right to hear complaints outside of the parameters, and that was passed 3-0. So the motion, as it was worded, didn't specifically mention a requirement of a signature, just that it be in writing. The form was referenced in some of the discussion leading up to the motion, and the form does have a signature line on it very clearly, but it is not clear to me from the wording of this motion, which I'm happy to pass down if y'all want to look at it in written form, that the signature was a clearly required component of the 30-day rule. Now, Mr. Fields, I think, said that, at least with regard to one of the complaints, when she subsequently signed it outside of the 30-day timeline, she also annotated it additionally?
I believe that was the case for the 8-7 complaint. And again, I can't produce that original.
When you say that, you're talking about where she added the additional language at the bottom and the top that seems to be starred.
So it would strike me that that language would be untimely, that additional annotated language. That is beyond the 30 days.
Can I play devil's advocate just a little bit? It seems to me that the 30-day requirement requires a complaint to be filed within the 30 days. And I look at this TLC complaint form here, revised June 20th, 2018, and down to the signature line where it's very clear, says form must be signed or it will not be processed. Wouldn't a complaint include, for a proper complaint, would include the signature line?
So it is not clear to me from the motion that is right in front of you at this point, the way the motion is worded, that you actually had to put the complaint in that form in order for it to meet the requirement of the 30-day rule.
It just has to be in writing. So she could have written it on a piece of notebook paper, technically, and handed it over, and that would have been sufficient.
Arguably.
Final question. Complaint form will be mailed.
That is the only reference to it, and that is not in the motion itself.
How did Ms. Robinson get this complaint form?
I assume it was mailed.
I suspect she pulled it offline.
Okay.
Didn't file. Then I think it was actually sent through an iPhone, which is sometimes done, where a photograph's taken.
So if the complainant decides to use the TLC complaint form, which does say it must be signed, are they not then, is it not incumbent upon them to sign it?
I mean, it wasn't a part of the 30-day rule that the form was adopted in its, I mean, the way the motion was worded in the minutes.
Sounds like we need to clarify the motion, or what was amended to include must be signed as well.
Yes, but I don't think that could have retroactive
Yeah.
effect.
Right, no,
But-
not retroactive going forward.
You know, and someone who is not,
There's going to be a lot of
someone of the public who is not regularly attending down here with complaints, we ought to be able to give them some latitude to be able to write a complaint out and submit it and not have to necessarily use the form. Someone who's not familiar with the procedures down here, who may have a legitimate complaint. But, okay. Did you find your unsigned ones?
Want to see the wording
I think we were dealing with two that we had copies of that were unsigned. One of them, as I mentioned, was the business license one on 6/23. The second one that was filed the same day, 6/23, it's not the business license one. That is the parking consistently, repeatedly parked outside of the carriage stand. That was submitted without a signature. I do have a copy of that.
That's the original that was sent to us.
And Mr. Blackburn, what about the August 7th, 2019? Was that one signed when you received it?
No, it was not originally signed, but then she signed it. I have the original one.
Where is the original
I
of
just
that?
handed it to you, hold on. And it came back with all little notes all over it.
Right, I know the
I have
notes
the original.
were added. I just wasn't sure if it was already signed.
You hand it to me.
Yes, I put it right here.
I'll pick it up and hand it to me again.
Is it in there?
And of course, the 30-day rule does give you some discretion as well.
There.
It did say that if you chose to consider something that was outside of those
the
parameters
original.
under appropriate
This
circumstances.
is all the new stuff.
Somewhere else, this stuff's even taking place.
She did sign it.
What the arguments are that Mr. Blackburn's made. So with respect to the complaint dated June 23rd, 2019 from Ms. Robinson, there are two grounds for dismissal. One, that it was not timely filed, and two, that even if it is considered to be timely filed, it is too vague on its face to be considered because there are no allegations regarding, the specific carriage, the time. Although I do note that the date was indicated as June 1st, 2019. So that's the grounds to move to dismiss that complaint. Then we have the complaint by Ms. Robinson dated August 7th, 2019, and the grounds for dismissal of that complaint, again, is that it was not timely filed, it was not signed until after the 30 days, and a second grounds is that on its face, the allegation does not state an actual violation of the Metro Code. And then the final complaint before us is dated September 9th, 2019, and as far as I can tell, the motion to dismiss really seems to be going to the merits of the complaint.
I think that's all correct, Mr. Chairman. The one in August there were two filed because we have the one that's modified, and it's from that it was inferred that it must have been altered. That's the one we're supposed to defend, and that was not within that number of days. The other two, you're correct. The one on September the 9th is the one that pertains to lighting. Well, all it says is that it was operated downtown without proper lighting. That is not a correct statement, but that doesn't state in what way the lighting was not proper. I think what the ordinance says is that it has to be done in accordance with state law, which I believe would mean it has to have the triangle and the rear lights.
Running lines.
We do have, this would be more on the merits, but we do have time-dated pictures of that very carriage with, on the dates she's claiming, with lights.
Time stamped on them days.
Well, it's not appropriate for a motion, but I would say I would adopt what the chairperson has, the way the chairperson has characterized the legal arguments so far today for all three complaints that are before us. I'll make a motion to dismiss the June 23rd, 2019 complaint brought by Melanie Robinson against Sugar Creek for allegedly blocking crosswalks, double parking.
All those in favor?
Aye.
Any against? Motion passes.
Was the second Commissioner Rogers or Commissioner Carr?
Mr. Rogers. Did you vote, Freddie, or were you abstaining?
I'm going to abstain.
Okay. And then,
I'll make a motion to dismiss the August 7, 2019 complaint brought by Melanie Robinson against Sugar Creek Carriages, alleging that they are operating in the rain.
Second.
all those in favor?
Aye.
Motion passes.
I would make a motion to defer the September 9th, the complaint dated September 9th, 2019, brought by Melanie Robinson against Sugar Creek for improper lighting. While I respect the arguments made by counsel for Sugar Creek about the ambiguity in the language that's in the complaint, I think we should give wide latitude to the language used by folks in this, and I would like to see what proof, if any, Melanie Robinson has regarding the improper lighting. I remember very clearly there was a complaint brought against her for improper lighting on the back of her carriage, and we had pictures and videos and everything, and I think giving the importance of lighting, proper lighting on carriages, I would like to see what proof, if any, she has on this particular complaint.
I agree, and I'll second.
All those in favor?
Aye.
Motion passes.
Thank you, Mr. Chairman. One last thing. I think it would be, if I may suggest this, be useful to clarify the rule has been discussed. If the form does not have to be signed, you could have complaints done by an email, for example, theoretically. There's been the requirement that these be submitted under oath, but the form itself doesn't have any oath language on it. These things are, I totally agree with wisdom of the motion that you made in 2018, or that was carried in 2018. This is the doctrine of unintended consequences. Now we've got to figure out how to tweak it, and I think just making it clear that what the form says, if the form says it won't be processed, then there needs to be some means just not to process it and to advise the one who's submitting it of that it's not being processed. And then we wouldn't have to have these discussions.
The rule change does require prior notice and a public hearing.
Mr. Blackburn, before you leave the podium, I have a question.
Yes, sir.
Because you are usually in the thick of these complaints, defending them and sometimes prosecuting them. What would be your thoughts regarding a cost bond attached to filing a complaint by the complainant? Let's say a $500 cost bond to...
I think that that might lend an air of reality to the decision to put your name on the complaint. I think that's a good idea. What's happened here historically, this was in response to Madam Commissioner's statement, when I got involved in this, there were far more carriage companies, and there were far more carriages. And in the meantime, traffic and parking had limited the amount of space. So you had if you recall, what I described as those experiments that psychologists have done where you put a whole lot of rats in a small space and they wind up fighting. I don't want to characterize any of our people as rats, but I think the phenomenon...
Your client might not appreciate that.
Some may not.
But I've heard there's a rat in the barn.
I'm not going to call a rat the man who hired me to be here. So, but I think that phenomenon was at work. Then we had prior controversies that I was made aware of before I became active in appearing here, where there were inspectors who are still employed, and these inspectors were criticized by the chief of police for using blue lights and various other things, and he was alleging that they were acting outside of their scope. The end result of that was that inspectors quit regulating downtown carriage operations. So the only enforcement mechanism you had was to place the ability to bring charges in the hands of people who were financially interested in the outcome, which created motivations and all sorts of things. A year ago, we worked out an understanding with one of the competitors that we call it an armistice. One of the reasons was we did in fact agree to that on Armistice Day, November the 11th. And for many months, you will note that Sugar Creek filed no complaints against that competitor, nor did it file any complaints against Sugar Creek. The ones who persisted in this were the animal rights people. I'm not being critical of them, but they did file complaints. We had no control over them, and Miss Robinson. And I don't want to rehash her issues and how this came about, but they continued to do. Those two continued to file complaints. There were reasons why Sugar Creek filed if I can use an East Tennessee expression, a slew of complaints. Recently, you mentioned the 16 or whatever it is, and that's because of some things that have to do with the issues in the lawsuit that we've filed that I don't need really to discuss here. However, I have suggested many times over the years and had lawyers for these other companies agree that we could set up a situation with alternative dispute resolution means, and that would make a great deal of sense. Mr. Smith was willing to do that. The lawyer originally for Hat Creek, which is no longer in business, that gentleman retired, could not get his clients to agree to it, so that didn't go anywhere. Then there was a suggestion that some of these could be heard more effectively just by the director himself. In fact, as Mr. Fields will recall, last time we were here, I made that suggestion about any number of these 16 that are filed. I think having one other thing that I had suggested was that a surcharge on these rides be made so that a private entity could be employed in order to supervise this and play the role that a inspector previously had played. I even proposed. I had a proposal from a particular security company that was willing to do that. I understand why that would be difficult for a commission to do, and who else had to be involved, and getting involved in the mayor's office and all sorts of issues. But at any rate, it's not that we haven't made suggestions about how to stop this. And I will say, since we're being filmed here, and Mr. Smith can confirm, I have told Mr. Smith that these folks need to start figuring out how to deal with these things. I suspect that if this commission had the authority to just stop the carriage trade, they might have exercised it at some point over the last few years, and that this is not wholesome. The ironic thing is that there are far fewer carriages in operations now.
Yes.
Ms. Robinson has told you that she's mostly working out at Opryland. Mr. What's his name's company? Is that who runs that? She works for Mr. Morrison. Her carriage and her animal are sort of leased, so to speak, to him. She operates out there. So we have a couple of companies that operate downtown. There's more business than these operators can handle, and they just need to start getting along. What was the fellow in the famous case in Los Angeles where the man was beaten by the police? His famous phrase was, "Why can't we just all get along?" We're willing to cooperate with that any way that the commission wishes for us to.
Can I say something, sir?
Yes.
I would like to put back in effect the armistice. The reason that it was taken away was social media attacks on my company. And not just that, though, there was violations that I kept putting my drivers off from filing complaints over the past whole 11 months. I wouldn't let them do it. But I would like for the armistice to go back into effect. But
Would the good faith effort be withdrawal of the 16 or 18 complaints that are present?
yes, sir. But Mr. Fields,
We'll take that.
this also goes along. If I could
Accept it.
convince my drivers to, that they're the ones that I withdrew mine, which is, by the way, the only complaint that I ever filed against Southern Comfort. I would like to have the armistice come back into effect if Southern Comfort and American Melanie would quit ganging up on me for the past 3 years trying to put my company out of business.
I'd like to have the opportunity for the next meeting to talk to Mr. Smith about what we can do about the profusion of complaints that are in the pipeline.
Thank you.
All right, thank you.
What does anybody else think about discussing, obviously, like you said, it would have to be at a future meeting, the idea that Mr. McNally brought up of imposing some sort of fine attached with filing a complaint?
It's called a cost bond, but I think there's some issues about we cannot generate money and
Yeah, I'm concerned about that idea just because I don't know of any other board or commission that has such a requirement, and I assume there's a reason for that. But I would have to research it to give you a more intelligent, informed response.
would you do that?
I would.
Because I do think it would cause complainants to pause and
Only bring
evaluate whether they
serious
really want to
matters,
bring it.
yeah.
But I can also see why it shouldn't be exorbitant. $500 to bring a complaint seems really high to me, especially at this level.
I pulled that out because when you file your notice, when a person receives a forfeiture notice that the police have taken some property, to file your claim of ownership, you have to attach a $500 cost bond, which is burdensome.
And I think, oh, go ahead.
Sorry, I was going to say it would apply across the board, so it would apply to customer complaints as well.
Yeah, and that's what I was going to say. We don't want to deter complaints from customers as well as other vendors, not just carriage companies, from making complaints because they have to put up a $500 bond to make that complaint, because I couldn't see how we could keep it from not being a broad sword, so to speak. And the whole purpose of us being here is to hear those complaints, be it they should be on a limited basis. I would venture to say I would like to explore more along the lines of a limited amount of complaints, or the complaints maybe being reviewed before brought to us by Mr. Fields.
One of the issues that we had, and we've certainly met in legal multiple times to work through it, is on carriage complaints, I actually have the authority to have administrative hearings. However, the issue of appeal is a strange thing. So what it appears is I would have the hearing, I would make a decision. That decision then can be appealed to the commission. So what ends up happening is we have a full hearing. I spend a day dealing with it. Then you spend an hour dealing with it, because if they disagree, they're going to appeal.
Can either side appeal the complainant? If the complaint is denied, then the complainant can appeal to the commission?
The way it's written in the ordinance, is my memory of conversation with Ms. Costonis, is it's not clear. In other words, so we think it's a full appeal where it's a full hearing, not a review of the facts that were generated in the hearing, but a review that you would be back to doing evidence. So that's the reason that I had originally said that we're going to do that, and until we resolve it, I think it becomes, I spend about 80 to 90% of my time on two things: horse carriages and scooters. Mm-hmm. Now, the rest just doesn't rise to, it just takes so much time to deal with those issues.
The complainant does not have a right to appeal. It says any permittee whose license has been suspended or revoked by the commission director may file a written appeal with the commission within 10 days. So that is only a right of the permittee.
I'm sorry, go ahead.
I was going to just say, so if the complaint is dismissed, Mr. Fields could actually be a screening process to where some of them, where he finds there's no merits or whatever, they'd be dismissed, and that would be the end of it.
That is how the rule is.
Which would,
that is how the code provision is written.
which would bring fewer up to us on appeal. Okay. Sorry, yours?
No, I was gonna say, is it within our rights or provisions to limit the amount of complaints per vendor, per complainant, to so many within a certain period of time? Certainly not limiting the complaint, but limiting the amount within a period.
So, I guess I would say any rule that you want to adopt like that might need some discretionary out, because your primary concern is public safety. And regardless of the source of a complaint, if it raises a significant public safety concern, you might want to have the discretion to hear it regardless. And then if we do create kind of a discretionary out, like I'm talking about, we could end up kind of being subject to charges of selective prosecution if it seems arbitrary in the way in which that discretion is being exercised. So those are kind of the risks I see with putting some kind of hurdle or burden on the front end on filing a complaint.
And I only wanted to visit that because, like Mr. Field said, we service so many other transportation factions other than carriages and scooters, yet they take up 80 to 90% of our time, which is not fair to the rest, to the taxi cabs and the limousine companies and all the other companies that we're here to serve. If we're spending 80 to 90% of our time on two particular sections that we're here to serve, to limit it in that way as not to abuse the other people we're here to serve.
Yeah, and I completely agree, and it's something also that we need to be respectful of Mr. Fields' time. I understand that this is a part of his job, a part of our charge for being here, but at the same time, there has to be a balance, and I just support everything that Mr. Carr just said.
All right, well, I don't think we need to make a motion. I think it's good we're having this discussion, though, about how to procedurally handle some of the volume of these complaints. Mr. Fields, is it all right to proceed with the next complaint?
I think so.
All right. We also have a complaint by Keith L. Wall against 5 taxi cab drivers. Burhan Adesalam, Wande Adeniyi, Gedahun Getu, Gashu Binti, and Tesfahi Maraye.
You did a very good job with that.
I'm not sure. Mr. Wall, Keith Wall. I spoke to Mr. Wall on the phone. This complaint on the phone. This complaint originated in August. I thought it had been resolved. It had not been. I spoke with him on the phone. I did not send him a written notice to appear. We did notice the drivers. Unfortunately, 2 of the drivers are actually out of the country. So the complaint basically was a single complaint with 5 drivers all being charged with the same issue. Since Mr. Wall is not present, it may be appropriate to just defer the action until they are available for a hearing. Or, again, Mr. Wall was, as far as I'm concerned, I gave him notice on the phone. Since that was not in writing, I certainly see that it's possible that someone would say, Mr. Fields did not tell me that. As has been said, there have been a lot of accusations and a lot of comments made about your director's ability to do the job to start with, and his capability and professionalism, and I certainly don't want to feed into that by not giving someone notice. I do know the drivers are present, or at least a couple of them are present. No evidence was presented outside of this the complaint. But again, two of them are out of the country and could not be here.
Which two drivers?
The first two, Burhan and Wande.
And so all the evidence is verbal, no photos, no pictures of the...
I could describe what I was advised had happened. He basically went to a stand and began asking for the rides, and the rides were not going to be. He believed they would be meter rides. He said they were actually asked for a set fee prior to leaving. A driver does have the right under the law to ask for money prior to a ride. They also have the right to in certain cases, to refuse the ride. So again, without him being present, I don't know if there was anything else, because I don't know what the drivers might say today. I mean, they may very well say that this happened or that happened, which is within their right to do. And again, I'm not trying to judge it one way or the other. I just don't have any information other than what's here.
But given on the description of the incident, there are no violations as he himself put in the description, because he was asked for a flat meter or a flat rate. That is not actually a violation, that the taxi cab drivers actually have the right to do that.
If we reviewed each one at a time, 220 is a section of the ordinance that discusses duty to render service. In that particular issue, in that particular section, it talks about a driver, certain things drivers and companies should do. One of the things that should happen is it talks about a holder of certificate must accept a call anywhere in the area. So I'm assuming that, so he's actually aimed that against the company. I'm not sure you can actually consider that, because the company, this is aimed against the driver, not a company. By proxy, you could say the company is directly related to the company, therefore I knew those kind of words. They would have responsibility for the driver. But again, I think that might be a questionable one. Again, for me on the front end, on 265 is the next one, and that basically is about the taxi meters, and you have to run a taxi meter. The only time you don't run a taxi meter is if a flat rate's in place. In this case, the only flat rate that we have currently is the triangle rate, which is downtown to the airport to Opryland. I have no information whether or not that his run was going to be from the point of downtown to Opryland or to the airport. And then 270 is involved the payment of fares, and it talks about that they have to accept credit card and they have to provide a receipt. In what some would argue, and again, I don't want to argue, I'm not their representative. However, if no money exchanged hands, I'm not sure you could deal with that either, because regardless of what was said, if no money exchanged, there can't be a violation. If there's no ride, then there's no money. Now the question becomes, did they refuse the ride for no other reason than they wanted a short ride? One of the historic reasons cab drivers turn down runs is they don't want a $5 fare, which is giving rise to the transportation network companies. And they all know how I feel about that. And I'm not saying they did or didn't. I'm just saying that's been a problem forever. It's a much bigger problem now.
Well, that's not even alleged against.
No.
In fact, so.
No.
The allegation is collusion to gouge customers based upon racial basis. That doesn't fall under any of these code sections that have been that you've just described to us, Mr. Fields. Yeah.
The only real concern I have is Mr. Wall complaining and may not have gotten a proper notice that, although I gave him a verbal notice, and because we actually talked about it after I talked with him on the phone in the office. So the call happened, but I don't have a transcript.
I'm going to make a motion to dismiss the complaint brought by Keith Walls based upon the allegations described in the complaint, that they do not The facts do not merit a complaint against the drivers. So I move to dismiss.
Second. Is Mr. Wall here?
No.
It's not.
Okay.
We have a second by Mr. Rogers. All those in favor?
Aye.
Motion passes. All right, Mr. Fields, any other business?
I will thank you for another year of service to the government. This is your last meeting of the year. As I indicated in an email to you, a new ordinance has been submitted. It'll be on first reading Tuesday. That will be dealing with the SUMDs and scooters, and the process will go forward. I will, as this goes forward, obviously we'll see what amendments come, but we have more work to do on scooters.
And so do you want us to be at the present at the, okay.
Not Commissioner Rogers saying I'm there, and I don't think you should be. No, I don't think, at this point, I don't think it's necessary. I think what may be necessary, what will be necessary is a meeting, whether it's a regular meeting, depending on what your agenda ends up being, to consider whatever the RFP process, what comes back. Because you are still, even though it's a new ordinance, it comes right back to you and to the office. So you don't have.
But if any of you have suggestions, we'll be glad to carry them to the sponsors.
Absolutely. If you have any suggestions, any thoughts that you'd like to have considered as an amendment to the particular ordinance that I sent out to you, please let me know, or even better, I like to do this, Ms. Castona, since she is much better versed in legislation than I am.
Billy, you passed out some notebooks to us
What
before the meeting.
you have, as you know, every January we have an annual meeting to consider applications for taxi cabs, either additional taxi cabs for a company or a new company. There was one application filed by the deadline in December. I went ahead and gave you the paperwork today. We'd had a request, someone had heard there'd been an application, and I felt like since that was already there, it was a public record, I wanted to formally make it a public record to provide it to you.
Thank you.
I hope you all have a great holiday season.
Move to adjourn.
Second.
All those in favor? Aye. Motion passes. Thank you.
So you need my